Thank you. I have lost a lot of time. I hope you will be considerate. I somehow lose the 10 minutes that you have afforded me. But I was making a point, a preliminary point, that by their very nature, constitutional issues are not rocket science. They are everyone's issue. And that's why in our country, which perhaps because people are too much into textbooks, they think that constitutional issues are an exclusive preserve for lawyers. And yet, in fact, these issues are important precisely because they are everyone's issues in the literal sense. That's why a good constitution or a good constitution moment such as this one is the one that has something for everyone. And when that is clear, that's when the lawyers come to draft. But drafting what is not coming from their heads, but is coming from the aspirations of the people, in this case, not only through such conversations, which started on Monday, or more technically on Tuesday, the counting of the 90 days. Yeah. Otherwise, I would like to thank you for this opportunity. I want to start by pointing out that a presentation to a discussion of this nature must, in my view, begin by stating what the essential and critical issue is, which happily in this case, it is common cause that it is about the Constitution of Zimbabwe Amendment number 3 bill, approved by Cabinet last week and gazetted by Parliament this week. As one among many others who have been intimately involved in constitutional reviews over the last 26 years, notably during the people-driven exercise that produced the 2000 draft constitution prepared by the Constitutional Commission and the compromise constitution between ZANU-PF and the two MDC formations that produced the current constitution. It is my considered view that the Constitution of Zimbabwe Amendment number 3 bill represents a profound recalibration of our country's democratic or political architecture. So, the foundational question of my intervention this morning is based on this question that I pose. What is the motivation or mischief that the bill is addressing? It's not coming just dropping into our midst or political body politic like manna from heaven. It is a response to a particular situation or mischief which motivates it. And to have a meaningful debate, I think it is important to unpack or understand that mischief. In my view, the mischief being addressed by this bill is twofold. This is, I emphasize, my view. One is that there's this perpetual conflict mode in our country arising from its system of electing the president, which was introduced in 1987. We should bear in mind as we debate this, that when this system was introduced at that time, it was in anticipation of the establishment of a one-party state. The 1987 amendment was enacted with explicitly intentions of establishing a one-party state in our country. And then things happened. And by 2000, the government set up a constitutional commission to review the entire constitutional edifice of the country, but in particular, consequences that had arisen as a direct result of the introduction of the executive presidency in 1987. The 2000 constitution, draft constitution that is, sought to address this issue under a hybrid compromise that sought to bring back the office of the Prime Minister, drawn from the party in Parliament commanding the majority, as the head of government, while retaining the President as the head of state, but with reduced executive powers. Unlike the 2000 draft constitution, at least from the point of government, since that process was a government process, the 2013 constitution did not even attempt to address the issues related or rooted in the 1987 amendment. Instead, it retained the presidency, the executive presidency, created in 1987 in anticipation of a one-party state, but this time retaining it under a constitutional framework for a multi-party democracy enshrined in Section 32A of our Constitution, and which framework has a running thread throughout the rest of the Constitution. The Constitution enacted in 2013 presupposes the existence of a multi-party democracy. But the executive presidents, which was inherited without even a single amendment in 2013, was, and this is an open secret, but it is an objective structural question. It was enacted anticipating that by 1990 or after the 1990 general election, there would be a one-party state. But it didn't happen. The fact that this was retained in 2013 by a constitution whose framework anticipates a multi-party democracy naturally led to a self-evident structural breakdown which has spoken for itself since 1990, exemplified by the scourge of disputed presidential elections and the toxicity associated with it. That's the first mischief that the amendment or the bill is addressing. The second mischief is that over the years, but this is a colonial or pre-colonial problem of all countries that were under colonialism, such as Zimbabwe, which adopted a shorter 4 or 5 year term of office for the elective institutions, namely the executive and the legislature. The adoption of these short term of office provisions or structures or election cycles has been problematic in that the period is too short and tends to perpetuate permanent election modes, with the next election starting immediately after the last, breeding populism over service delivery, exacerbating societal divisions, ethnic divisions, and leading to bureaucratic inefficiency. Data from at least the 16 African countries in the Commonwealth shows without doubt that shorter terms of office adopted in post-colonial constitutions, ostensibly to promote democracy and accountability, often have tended to incentivize divisive rhetoric, divisive politics, ethnic mobilization, and critically, the neglect of long-term infrastructural development within fragile context, which have weak institutions, and which perpetuate instability, such that the traditional enemies or grievances of the people that fueled the nationalist struggle, hunger, poverty, disease, ignorance, have not been addressed. They are difficult, if not impossible, to address within shorter election cycles. Therefore, in my view, by amending sections 92, 95, subsection 2b, 143, subsection 1, and 158, subsection 1 of the Constitution, the bill addresses these two mischiefs. And it does so not by altering the structure of government or its fundamental institutions, but principally or in the main by transforming the system of electing the president and the period or the duration of the national election cycle, which affects only two branches of government. Those people who talk about power, whether it's executive power in Section 88 derived from the people, or the legislative authority derived from the people, and saying therefore you must have direct elections, must confront the reality that judicial power is also derived from the people, but the people do not directly elect the judges. But in any event, the point is that this reform package, constitutional reform package, whose core amendments are those that I've outlined, directly tackles these two situations that I outlined just a little while ago. In the circumstances, the reforms in the bill are neither cosmetic nor partisan. They are historic, strategic, forward-looking, and deeply patriotic. In particular, the reforms in the bill seek to strengthen Zimbabwe's hybrid electoral system, which has developed to be one of the best, the hybrid election system that is, in order to align it first and foremost with Zimbabwe's constitutional realities going back to at least 1987, as I pointed out, and to also, in the second instance, align it with proven best practices in the SADC region and in the Commonwealth, which Zimbabwe seeks to rejoin. All told, the reforms position Zimbabwe for institutional maturity and enduring stability. And in this regard, quickly, but hopefully without losing much of the content, I would like to highlight 5 or so underlying principles that are necessary to understand if we appreciate what the foundational question is in terms of the mischief being addressed and what the core amendment seek to do about that foundational question. So quickly, 5 things. Firstly, and at the heart of the gazetted amendment, lies a foundational constitutional principle under Section 117, subsection 2A of the Constitution. The principle is that the current 10th Parliament possesses unassailable authority to amend the Constitution in accordance with Section 328. It is bound neither by the 7th Parliament that gave birth to this Constitution, nor by the 8th and 9th Parliaments that enacted later amendments to it in 2017 and 2021, respectively. This legislative independence of the 10th Parliament is not a technicality. It is the living expression of the democratic doctrine that one legislature cannot bind its successors it is called the anti-entrenchment rule. No parliament may forever shackle those parliaments which come after it. Each new parliament is sovereign and retains the unfettered right to repeal, amend, or replace the laws of its predecessors. To deny the 10th Parliament this principle would, in my considered view, be a dangerous surrender to the tyranny of temporal majorities, allowing yesterday's choices to imprison today's realities or will. Permanent entrenchment of laws freezes progress and suffocates hope. The 10th Parliament, therefore, stands not merely authorized, but solemnly duty-bound to shape Zimbabwe's constitutional destiny with courage, clarity, and unyielding authoritative legitimacy. That's where legitimacy comes from, not from the whims and caprices of players in the political process. Secondly, the constitutional prescribed process for amending the Constitution is enshrined in Section 328. This section establishes a rigorous, multi-layered procedure designed to prevent hasty or self-serving alterations or amendments of the Constitution, while empowering Parliament to refine governance in response to evolving national situations and aspirations. This is why any constitutional bill must be published with precise terms, allowing at least 90 days for public consultation in terms of Section 3284, consultation and scrutiny, to enable the broad societal input. The bill must then secure the affirmative votes of at least 2/3 of the membership of both the National Assembly and the Senate at its final reading, a threshold that demands cross-partisan consensus. This way, the amendment process honors the foundational principle that the supreme law of the land derives its authority from the will of the people expressed through their parliament. This is in the Constitution. Thirdly, and critically, Section 328, subsection 6, reserves the ultimate democratic veto, namely the referendum or national referendum, but it does so only for the most sacred and entrenched elements of the constitutional order, namely any constitution bill seeking to amend provisions within Chapter 4, the Declaration of Rights, or Chapter 16 concerning agricultural land. Section 328, subsection 9, extends this similar protection to Section 328 itself, deeming it an integral part of the Declaration of Rights in Chapter 4. It is only and only in these three exceptional cases where a constitution bill having secured 2/3 approval in Parliament must be submitted to a national referendum within 3 months, in which approval by a majority of participating voters is indispensable. All told, the referendum in constitution making in Zimbabwe is not a matter of the wills and caprices of people who demand it or use it as a political weapon. It is strictly a matter of law, not conjecture or an expression of the desires and wishes of political players who invoke it usually for conflict mongering. Otherwise, for all other provisions that are in the Constitution outside Chapter 4, Chapter 16, and outside Section 328, such as those that are affected or specifically covered in this bill, the prescribed process demands nothing more than the parliamentary threshold of 2/3 majority without a referendum. This is a constitutional position as it is. The 2013 Constitution, in its wisdom, mandates referendums only for amendments that I outlined. Any demand that referendums extend to other provisions is, and I emphasize this, illegal and unconstitutional. That we can pronounce. Some people pronounce amendments as illegal. They are not, because they seek to change the legal position. But how those amendments are made is a matter of law as prescribed under 328. Fourthly, there are claims that amending a term limit provision necessarily triggers a referendum. This is false in my respectful opinion. Recall that the Constitution mandates referendums only for amendments to chapters 4 and 16 and section 328. There is not even one term limit provision that falls under these parts of the Constitution. And this is not to say anything about the bill, but to say something about term limit provisions. There are 15 term limit provisions in the Constitution, and none of them is touched by this bill. So, and in fact, conveniently, these were circulated or shared yesterday by the Attorney General. And there is, however, an exception under section 3287, where or if an incumbent is to benefit from an amendment to a term limit provision, not any other provision, but a term limit provision, then section 3287 is triggered and a referendum might be required if the intention is to benefit an incumbent who holds an office which is subject to which has term limit provisions as defined by the Constitution. But to be clear, Section 328, subsection 7, comes into play or imposes a referendum only if an amendment is to a term limit provision. And we should underline that, to a term limit provision and not to any other provision. And if the amendment extends an incumbent's tenure for someone who held the office before its enactment. Section 328, subsection 7, provides that notwithstanding any other provision of this section, an amendment to a term limit provision, the effect of which is to extend the length of time that a person may hold or occupy any public office, does not apply in relation to any person who held or occupied that office or an equivalent office at any time before the amendment. I emphasize, colleagues, this applies to an amendment to a term limit provision. It's not only term limit provisions that talk about time. There are many other provisions in the Constitution which are not term limit provisions, but which have something to do with time. An example being Section 95, subsection 2B, and Section 143, subsection 1. Or even Section 158, subsection 1. But we have to be clear. The operative phrase in Section 3287 is that the affected amendments must be a term limit provision, not any other. And subsection 1 of Section 328 provides that a term limit provision means a provision of this Constitution which limits, the provision must limit, which limits the length of time that a person may hold or occupy office. If the provision talks about time, but does not limit, does not put a cap on the time, then that provision is not a term limit provision. For a clause or section of the Constitution to qualify as a term limit provision, it must expressly and unambiguously put a limit or a cap on the time that a person may hold or occupy the office. If there is no limit or cap in that provision being looked at, then that clause or section is not a term limit provision as contemplated in Section 3 281. Using dictionary definitions of the words term and period, the Constitutional Court, in the landmark case of Max Mupungu versus Minister of Justice, Legal and Parliamentary Affairs and 6 others, held that, I quote, a term is defined as a fixed or limited period for which something, for example, office, imprisonment, or investment lasts or is intended to last, while a period is defined to mean a particular length or portion of time. In other words, in the language of section 143, subsection 1, a duration of time of parliament is a period. In light of these definitions, a term is a period. This is in the Mupungu judgment. In the light of these definitions, a term is a period of time which is ordinarily measured by using a particular unit of time and which has a known beginning and a determinable end. The operative word is that, unlike a period or a duration which might be subject to contingencies such as age or election cycle, which can't be fixed exactly unless you are in jurisdictions like in the United States, where it is known that every 2 years, the first week of November has national elections, congressional elections, for example. If an election cycle is provided, subject to, and so forth, his contingencies, then it is a duration which is not, or which does not have a known beginning and a determinable end. Therefore, a term limit in this understanding is a cap on that non-beginning, a beginning which is known and an end which is determinable. As such, term limit provisions place a measurable lid on tenure with unyielding limits like non-renewable term, renewable once, not more than 2 terms, or totals such as up to a maximum of 2 terms, or renewable once subject to competence and performance, and so forth. All term limit provisions in the Constitution, the 15, guarantee no endless or contingent extensions. They guarantee specific ends, not the kinds that are endless, open, or contingent. Fifthly and lastly, the following stands to reason from the foregoing. 1, the bill does not alter or change the presidential term limit in section 91, subsection 2. 2, there is no third term or the repeal of the presidential term limit. 3, there is no extension of the presidential term which can be done only in section 91, subsection 2, which is not included in the bill. 4, sections 95, subsection 2B and 143, subsection 1 are election cycle provisions, and they are critical for that purpose, and they are found in all governments, democratic, monarch, communist, and so forth. They all define the period between the election of one president or head of executive and the next, or the legislature. It is crucial, not just as a matter of public law or constitutional law, but as a matter of civics 101, to know what is the election cycle of the government, the elective part of the government. It's an important civics lesson, and that's why in our case we didn't introduce these sections 95 subsection 2B and 143 subsection 1 in 2013. We introduced them in 1980. We had them throughout the 37 Mugabe years. Why? Because for sections 95 subsection 2b and 143 subsection 1 are election cycle provisions, not term limit provisions, and they do not belong to the protected category of term limit provisions that require a referendum. 5. There is no implication arising from section 3287 because that section only affects term limit provisions and not non-term limit provisions which are amended in the bill. 6, the bill only lengthens the election cycle from 5 to 7 years to break the toxicity of a permanent election mode in between elections. It's a Sabbath solution which everyone in Zimbabwe has had, from the churches who came up with a Sabbath proposal in 2021 to NTA who have their own Sabbath proposal, and it is in the body politic. The Sabbath proposal is in the psyche of any and everyone who has bothered to reflect on this proposal. It is not conjured up in thin or from thin air. And it is important to say that as far as election cycles are concerned, the minimum is 2 years for legislative people. And the maximum that is practiced by various jurisdictions as we speak is 10 years. 4 or 5 years is the medium. But there's a lot of literature, and at some appropriate time we will share this literature, which shows that many countries, African countries, which now are seriously grappling with infrastructural policies and projects, which rely on presidential systems where there's the divisive direct elections and so forth, are reviewing this. We are not the only ones who are reviewing this. And as recent as in September, last September, Guinea made this transition to 7 years. So the bill number 7, the bill is not about the president. It is about the presidency and about parliament as institutions, not members of parliament, not the president. And for the avoidance of doubt, in order to understand that section 95(2)b is not a term limit provision affecting the president. Consider this scenario. A presidential successor under section 101, following, say, a resignation of the incumbent or removal or a death of an incumbent after they've served, say, for 2 years. When that happens, the successor assumes only the remaining period of the term of the election cycle. If the election cycle is 5 years and the incumbent goes after 2 years, the successor just serves for 3 years. And this ensures continuity of the cycle without restarting the clock or a fresh term. This alone should settle the question that the period of 5 years does not belong to the office holder. It belongs to the office and can be held by many or several office holders. The same scenario is true in connection with a parliamentary by-election following a vacancy. In line with parliamentary term of office in section 143(1), the by-elections, they fill only the remaining election cycle time. One does not win a by-election to demand a full 5-year term. They win a by-election to serve a term started by the person who caused a vacancy for whatever reason but couldn't continue. I say again, if we are really serious, this should settle the question, because it's so clear that in both the case of the